Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast. And a big hello to everyone in between. As you can see on the screen, my name is Dan Balkaran, and I'm an employment lawyer at Samfiru Tumarkin LLP, which, as always, is Canada's leading employee-side employment law firm. As usual, I'm going to be answering all questions about all that you have about all things employment law for the next 30 minutes or so. Please submit your questions as soon as possible. I like to try to get through all of the questions in the broadcast, and the earlier I get them, the more likely that is to occur. Bit of housekeeping here, and you'll hear this throughout the broadcast, but I always like to start off with it just so you have it. If you need to reach us, get a hold of us for any reason, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Okay, let's get into it. We've got a few questions. Not enough, though, so please keep sending them in. I want to get to all of them before the end of the broadcast. Okay. I can't say this person's name, handle, so I just won't. So I don't want to identify them. My company was bought and all employees hired on with the new employer. If they don't keep us past 3 months with the new employer, are we entitled to any kind of severance? This is a very complicated question. Where does the 3 months come from? Is that the probation stipulation? Pardon me for a second. I'm guessing what you're saying is that you have a probation, you have new contracts and new employment contracts, and the contracts have a probation period that says if they terminate you within 3 months, they don't owe you any money. Maybe you can circle back and let me know if that's your situation. So acquisitions, and then when the employees are kept on, is a very complicated topic. So generally what the law is across Canada, but certainly in BC, is there are, broadly speaking, two types of acquisitions: the share purchase and a asset purchase. So share purchase is where a business ABC acquires the ownership shares of DEF. This happens all the time, and you work for DEF. This happens all the time, and it's just simply a change in ownership. That's it. Nothing changes with respect to your employment with the organization. And if the employer were to, so it's now ABC that owns DEF. If ABC DEF were to terminate your employment, it would owe you severance, as your entitlement has always been, which again depends on your what your employment contract says and your age, length of service, and position. So if you're a long service employee with no contract, it could be as much as 24 months, for example. So if it's a share purchase, nothing changes for you. However, if it's an asset purchase, I'm going to back up here a second just to explain what an asset purchase is. So an asset purchase or a share purchase is where one business acquires the assets and liabilities of another business. As an employee, you are effectively a debt over time. The employer pays you money across time, so you're a liability. But in an asset purchase, the acquiring company only acquires the assets, not the liabilities. And so there might be specific assets that the acquirer, the purchasing company, wants. So, for example, the example I always use is General Electric. So General Electric, quite famously, in the 80s and earlier, became this giant conglomerate, and it had like an aerospace division, a nuclear power division, a finance division, appliances division. It had a whole bunch of different divisions. And in the 2000s, 2010s, it started to sell some of those divisions for financial reasons. And yet General Electric, the business, still remains. So if you worked for, say, the nuclear power division, and then General Electric sold it to another company, you would go to that other company, but General Electric still existed. And so the new company was only buying the asset of the nuclear power business. It wasn't acquiring the rest of General Electric. Okay, so that's the distinction. And when there's an asset purchase, what effectively happens is that, or I shouldn't say effectively, what does happen is that the acquisition of the assets of the business that you work for terminate your employment at that moment. And so you do have an action for severance, it's against your old employer, the seller. However, if the acquirer offers you a job, i.e. the same job that you had more or less for the same pay, if you didn't accept that job, it would be considered a total failure to mitigate your losses and your claim would be worth zero, unless the job is substantially different than what you had before in terms of, or I would say maybe not substantially, but non-trivially different in pay or position, responsibilities, that kind of thing. However, when the acquiring company has you work in your job as usual with no change, doesn't give you a new contract, doesn't talk about your previous length of service is extinguished and it starts today, then even though effectively your employment has been extinguished, the law recognizes your previous length of service with the previous business so that your severance entitlement stays undisturbed, even in an asset purchase. Why I'm giving you this long, complex doctrinal explanation is because if the new employer, the acquirer, said, no, this is your first day of employment here, your previous length of service is not recognized, here's an employment contract that you have to sign if you want this job, and the employment contract contains, termination, a termination clause that limits you to statutory minimums, for example, that contract is binding upon you, and you're not required to get any. You don't need to be provided, or the new employer doesn't have to provide you with fresh consideration, fresh value for that contract to be binding. The actual job itself is consideration enough, and really, just to simplify, in an asset purchase, if the acquirer says to you, your previous length of service is not being recognized, you can start with us, and today is your first day, and here's a contract, you're bound by the contract. And so I think that may be what you're talking about here, in which case, yes, if they terminated you after 3 months, you would still have a claim, I believe, against the old employer, because you've only gotten, depending on how long you worked at the old employer for, because your employment with the new employer didn't last very long. But that's a very complicated situation, as you could see from me explaining some of the doctrinal background of it. So I would strongly recommend, you can give me more information in this broadcast if you have it, but I would strongly recommend that you speak to an employment lawyer if a situation like that arises. You're just asking a hypothetical, but if something were to come up there, I would talk to an employment lawyer right away. Or if you really need to know for your own peace of mind, then certainly talk to an employment lawyer. You can reach us at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. That was a very complicated question. Okay, question from Can an Ontario employer randomly choose or dictate what they determine as overtime, 55 hours as opposed to 44 hours? I'm going to go with no. I don't practice law in Ontario, but like every other provincial jurisdiction, if you were provincially regulated, your minimum legal entitlements with respect to overtime are going to be set out in the Employment Standards Act. The employer can choose to meet or exceed those requirements, but cannot violate them absent what's called an averaging agreement. So an averaging agreement would be, sorry, one sec. Okay, we got a few more here. An averaging agreement would be where you work overtime, but there's an agreement that in certain conditions, you agree with the employer that you're going to waive being paid overtime because it's to your benefit, and there's a certain structure to the form that you have to agree to, and an ongoing component that the employer has to meet under the Employment Standards Act in order to have the averaging agreement be legally enforceable. So an example of that would be, let's just say instead of working 5 8-hour shifts, you worked 4 12-hour shifts, and then you had a day off. That happens all the time with some businesses. I think nurses do that. And you all elect to do that in order to have that extra day off. However, theoretically, or not, I shouldn't say theoretically, under the strict letter of the law under the Employment Standards Act, from 8 to 12 hours in a given shift, you should be getting time and a half. But you waive that right in exchange for the day off. And I don't know if that math worked out exactly, but in exchange for the day off at the once a week. And so in a situation like that, you could agree to not be paid overtime under an averaging agreement, but there are strict regulations on how those are to be structured and ongoing components or obligations on the employer to make sure that they continue to comply with their legal requirements under the Employment Standards Act. But the short answer is no, they can't choose to, absent more information from you, can't choose to just say, we're not going to pay you overtime until you work 55 hours. That would be in violation of the Employment Standards Act and also the Canada Labor Code if you're federally regulated. If that is what's happening to you, you have to decide what the best course of action is for you. Are you losing out on enough money? What's your job security? Should you bring this to your employer's attention to amicably discuss it to work out a solution? Is this something where you bring a complaint through the Employment Standards Act? We call it the Employment Standards Branch in British Columbia, but whatever the board is, the government board that oversees employment standards disputes, whatever it's called in Ontario. These are questions you have to ask because, it may be if they are underpaying you substantially like that if you were to bring some sort of complaint through the employment standards regime, your employer may not be very happy with you, and you have to weigh that all out and figure out what the best course of action is for you. So I'll leave you with that, but the short answer is no, they can't set it themselves. There are minimum statutory floors in employment protection legislation. I can't identify this person. I'll just call them Z. Oh, now where can you submit your question? I believe that information is available on our website, employmentlawyer.ca. I'm not actually sure where you submit the question, but I'm going to, employmentlawyer.ca. It should be on employmentlawyer.ca. Question from HS. My employer refused my workplace accommodation requests. I suffer from anxiety and asked to have my shift changed to avoid some people who cause a lot of problems. What could I do to have them provide better accommodation for me? So did you provide a doctor's note saying that or saying that you're unable to work with those specific people on that shift because they cause you anxiety? If you did, you could bring a human rights complaint to deal with it. That's really your only avenue of redress other than the employer agreeing with you and accommodating you. I think it's much more likely to accommodate you if you have a doctor's note. I think there also has to be, though, a sort of an objective analysis of what you're claiming, right? Like, so why is it that they cause you anxiety? Are they behaving are they bullying and harassing you, for example? Or is it that you just don't like them? Or it just depends on what it is what the problem is. So if it's something that objectively may cause you, or it's a bad word to use, if it's something that there's misconduct on the part of these employees that's causing you to have anxiety, then it's incumbent, when you report it, it's incumbent to the employer to take steps to resolve it, in which case you shouldn't have to change shifts. Okay, so I would get a doctor's note, but a lot of this depends on what it is that is the problem, because it's not clear from your post. But I would say that there's certainly a reasonableness balance to that. So if they're bullying and harassing you and the employer is not dealing with it, I think that your request is one that would certainly be supported if it ever came to an adjudication through the Human Rights Tribunal or whatever it's called in your jurisdiction. But if it's not, then you may have challenges seeking any sort of remedy through a human rights regime. HB asks, can I get compensated for quitting my job after 2 years due to toxic environment and being mocked and belittled? It's a tough question. So if you were forced to quit because of a toxic work environment that was objectively toxic, then yes, you can. But you'll need a lot of evidence in support of that. Emails, reports that you can get documentation from in any sort of legal claim. So if you made 5 complaints to human resources because your direct superior was calling you names or something, recordings, whatever it is that you have in support of what you're saying, yes, you can get there. Those cases are amongst the hardest. So what you'd be doing is you'd be claiming that you'd be arguing that you were constructively dismissed by the actions or inactions of the employer. So if you didn't report this mocking and belittling and toxic work environment, or if it came from the management of the company itself, sorry, let me rephrase that. If you didn't report it, you're going to have a hard time getting to constructive dismissal. And so I'll just back up here a second. Constructive dismissal occurs where there's 2 ways to get there. There's a breach of a fundamental term of employment, by your employer that you don't accept. So think about a pay cut of over 20%, something like that. Or where the employer effectively repudiates the contract of employment, or your contract of employment, by indicating that it really no longer wants to be your employer. Under that branch, I think is where you're, if you have a toxic work environment, your employer is required to provide you with a non-toxic work environment. And if you report it several times and they refuse to do anything about it, then certainly that can be a constructive dismissal. But I think that I would say that there's a significant proportion of people I speak with think that their workplaces are toxic in some way, or that the company's toxic, or management is toxic. And the courts aren't in the business of commercially criminalizing mundane disputes or disagreements or failing to get along between humans in employment. It happens. People butt heads all the time. In order for your environment to be so toxic that you were effectively terminated by the actions or of the employer and not providing you with a toxic-free work environment, or not taking any action when you reported the toxic work environment, it has to be pretty serious. It has to be objectively considered to be something that a reasonable average person could not withstand. And so that's a lot harder because you need evidence. I mean, your statements and testimony could be evidence on its own, and it certainly could be compelling enough to carry the day. But that's tough. You really want to have supporting documentation, emails, recordings, other witnesses, pictures, videos. That kind of stuff can go a long way. So yes, it's possible, but you need a lot of evidence in support of it. Suzette asks, my employer is moving our base of operations to the next town over. It's going to add about 45 minutes to my commute time. Do they have to compensate me for adding to my commute? I don't think so. I mean, it depends on, I think a better question would be, are you constructively dismissed by the new commute time? So for example, if you had to commute an hour before, and that's a long way, but people do it all the time, especially when you're in a city and you live in the suburbs, or you work in the city and you live in the suburbs. In BC and Vancouver, for example, people commute from Langley, which is a suburb, to Vancouver all the time. It takes an hour sometimes. But if they add 45 minutes beyond that because they moved, is that a termination of your employment? And I think you can consider it to be that if the circumstances are right. I think that an hour and 45 commute each way is unreasonable, for example. But if you live 10 minutes away and now you live just under an hour away, I think that's fine. I don't think you have any claim there. But just to go back to what I was saying earlier, since we were talking about constructive dismissal earlier, constructive dismissal primarily, aside from when the employer is treating you badly such that you can't work there anymore, like was the case with HB. Generally speaking, what a constructive dismissal is where the actions of the employer, let me change that, where the employer breaches a fundamental term of your employment such that you can elect, if you reject that breach, to terminate yourself, in effect. Or a better way to say it is the actions of the employer de facto terminate your employment. So they cut your pay by 50%, or they cut your hours by 50%. And there has to be some permanence to it. It can't just be for a 1 week thing. Or in your case, they move the base of operations. They move where you work an extra hour away. Is it reasonable to have to commute 2 hours a day, 2 hours each way every day? No, I don't think so. I think that would be a constructive dismissal, depending on the circumstances. So I'll leave you with this here. Suzette, I don't know if this is a constructive dismissal. I don't have enough information. I also don't know if it's in your best interest to claim constructive dismissal. It might be, because you might have 25 years of service and no employment contract and have 24 months of pay coming to you potentially. Okay, so it just depends on your situation. You should definitely talk to an employment lawyer. If you, and you'll see the information on the screen, if you don't object to this change, you're effectively deemed to have accepted it after 2 to 3 months. Okay, so you have a short window to do something about this, or to find out if you have a good legal claim from this move, and if you do, if it's in your best interest to actually object to it and in effect terminate your own employment. This is very important. You cannot trigger constructive dismissal on your own. I mean, you can, but I would not recommend it. They're too complicated. They're too hard. You can get 0 if you get it wrong. Okay. So Suzette, talk to an employment lawyer right away. If you want to get a hold of us, you can do so at employmentlawyer.ca, help at employmentlawyer.ca, 1-855-821-5900. Okay. Sam asks, if my employer has given my position to one of my staff while I was off on medical leave, do I have to accept a different position if they're paying me at the same rate? It depends how different in kind the two positions are. If you went from CTO to janitor, no. But if you went from level 2 customer service to level 1 customer service, you might. Okay. So the employer has to reasonably let me rephrase that. The employer has to put you back in substantially the same position you had before, more or less, and not alter your pay. It seems, I don't know why this was changed, why they didn't put you back in your old position. You may have a claim, you may not. What makes it harder for you to have a claim is the fact that your pay didn't change. Right? Nonetheless, it depends on the specific details of what your job was before and what it is now. I've had multiple clients in the past where their pay was the same, but they went away on a leave and they came back and they had no duties. They just sat at a desk and did nothing. And would that be a constructive dismissal? Yes, it would be. So the real question is here is, there's two questions. Have you been discriminated against on the basis of a disability, in which case you have a human rights claim? And also, is the change in position substantial enough to trigger constructive dismissal? In BC, these are different jurisdictions that run in parallel to each other. I know in Ontario you can combine them. I don't know about all the other jurisdictions, but the question, it just depends on the details, Sam. So you should talk to an employment lawyer as well. I'll give all the details at the end here. Okay, Z is back. I work for a city in BC. I submitted my resignation in late April for a new opportunity. Due to the notice period, my last day with the city is today. A recent email sent in late May from the city announced market adjustment and merit pay increase from April 1. However, the email had a disclaimer stating merit adjustments will not be paid to employees who concluded their active employment before August 1. Okay. That doesn't seem fair to me. How do I defend my rights? Well, your employer doesn't, I mean, are you in a union? In which case I'd say talk to your union representative. But your employer is paying you X, and it can choose to give you salary increases or not. And then they gave salary increases to everyone else, but not to you because you quit. I don't see any issue there. I also don't see any way to get redress unless you're a member of a union, in which case you should talk to your union rep. But I don't really think you have a right to anything. You've already quit, and you're just saying I wanted the pay raise during the notice period. They don't have to. There's no obligation on your employer to give you a raise. If I work with 5 other people and all 5 get a raise and I don't have any legal right for that against the company for that, unless I didn't get the raise for discriminatory reasons, because my age, race, ethnicity, sexual orientation, gender, disability, ancestry, criminal record, that kind of thing. Okay, Jay's back. Good to see you, Jay. If one company were trying to acquire another, is that something your firm can assist with, or do you only deal with employment law? I don't really understand what you're saying. So in a transaction, there's lots of different components. So there'll be law firms that have giant solicitor departments where they deal with all of the liability assessment for transactions. Okay. Generally speaking, those are firms that they don't necessarily specialize in that, but a lot of big firms have mergers and acquisition departments. There's a whole bunch of things that go along with an acquisition. A lot of legal ink needs to be spilled on those things or on acquisitions in order to deal with any risks and liability that arise. So if you're talking about that, then no, my firm doesn't assist with that. We do employment law. So primarily we assist terminated employees with obtaining money or more money upon their termination. HB is back. Company brought me to a new city for my position. They were paying me a bonus for the first year and changed the goal so I could not hit the bonus for the second. That was that with the mocking from my boss. All right. I don't. Okay. So listen, if you employers will say to you, we're going to offer you all this pay, but if it's divided into salary and various bonuses and there's discretionary components to the bonuses, or the bonus, configuration can be changed, sometimes companies they'll figure out a way to not pay you those bonuses. Some companies never pay bonuses, even though they lure employees in with promises of bonuses. Really, it's your salary that counts, generally speaking. Now, it's not the case. Many employers pay a bonus regularly. Sometimes it's not even discretionary. It's just, if X targets are hit, you get Y bonus. So, but I don't think anything turns on that from a, I think you were the one who quit after facing harassment. I think the bigger question is the mocking from your boss. What was the mocking from your boss? Was that something that made your workplace objectively intolerable for you, that you couldn't work there anymore? And that's the question that you need to answer before you can claim that. So I would talk to an employment lawyer right away. We're almost done. Just trying to power through these questions. Shannon says, 7 years employed, always had an assistant, terminated the customer service rep and refused to replace, forcing me to take on that role. At a meeting, that I thought was to reinstate the CSR after 11 months instead. The employer said that they are slashing my territory in 2 and a new person is starting on Monday. Commissions would cut around $25,000. Also talked to workplace, and I have 6 testimonials proving this. Okay, well, the testimonials don't necessarily mean anything because other people say it's toxic doesn't mean that your experience was toxic. The slashing of your ancillary staff, your support staff, not really a constructive dismissal unless by taking away your CSR, you make way less money in commissions, let's say. Commission cut around 25%, that's a big deal. But if you make 400 or 25,000, that's a big deal. But if you make 400,000, it's really nothing. If you make 100,000, then you got something. Okay, so that could be a constructive dismissal, primarily around the cut in pay. Maybe the toxic workplace is enough, as we discovered earlier. Hard to get there on that. To constructive dismissal, but you have to decide if you want to trigger a constructive dismissal anyway. Is it lucrative enough for you to do that? You need to talk to an employment lawyer. I will post the information at the end here. Dave says, if someone works 20 hours a week, what vacation would they be entitled to? Whatever is listed in the Employment Standards Act. It's really based on your years of service. Shannon's back. Last question. No HR, no union. The excessive workload and bullying and harassment forced me to go on disability, which I've remained on since October 2023 with psychological damage. Any lawyer referrals? She listed her town. Sure, I can probably dig up a referral for you if you contact me afterwards. I will say generally, if you're on disability, there's my contact information at the top of the screen, Shannon. If you're on disability, most insurance companies have a clawback clause in their disability contracts, which generally means that if you get severance money, most of it is going to be clawed back against the disability money that you're getting, so you don't end up with any excess money unless you come off the disability. You're talking about a long time now. So if it's 2023, you're coming up on October 2025 at your limitation period for filing a lawsuit anyway. So you don't have a ton of time to investigate that. It sounds very, very complicated and very involved. So certainly you're going to need an employment lawyer. I'm going to put the last information on the screen. So if you need to get a hold of us, employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Z came back. City is providing retro pay from April 1 to active employees. I don't think you have anything with that. You have an individual contract with the city, so I don't imagine you have any redress for that, Z. Okay, join us on Monday if moderator hasn't posted this yet. June 9th, 1:30 p.m. with Eastern Time with Chris Justice. He will answer all things about all your questions, employment law. We had to race a little at the end to get all those questions through, but we did it. So I hope I answered everyone's questions. Thank you. Have a wonderful weekend, wonderful and safe weekend. I'll see you back here in 2 weeks in my usual time slot, 10:30 a.m. Pacific time, Friday. Have a great weekend.